Hi, everybody, and welcome back. Today we're going to talk about alibis and alibi corroborators across differential legal systems and contexts. And this is something that's important to also kind of note when you are starting to develop a new literature. And as social scientists, if you want to try and explain a phenomenon, one of the best kind of ways to explain that phenomenon is if it can take place cross-culturally. So, for example, if you look at theories like social learning theory in criminology, or general strain theory in criminology, or even the social control or self-control theories and bonding theories, the ways that we know that those are good, strong sociological theories and explanations of crime is because we've done cross-cultural studies and tested those theories and tested those concepts in different cultures. Social learning theory tends to rise to the top. General strain theory, for example, by Bob Agnew, that theory in cross-cultural testing does not fare nearly as well as social learning does, suggesting that perhaps as a theory of crime, that theory is not all that strong comparatively. It's still a widely accepted theory of crime, so I don't want to have that confusion there, but it isn't as strong of a theory as social learning when you look cross-culturally at those theories. If you recall from earlier lectures, there's issues in psycholegal research, and one of those is the use of mock jurors or mock investigators. A lot of the participants are white. There's studies using written vignettes that are relatively short. All of these things are limitations, but they also have a strong U.S. focus and U.S. legal system focus. What if there are other issues that might need to be addressed, right, because of these limitations? One of the chapter's goals is to address one of these major limitations, and that's Anglo-Saxon participants in an adversarial system, right? And so there's differences in systems, how alibis are generated in different systems are going to be discussed, and how these different systems affect alibi believability will also be discussed. So there's two major legal systems in the world: civil law or inquisitorial systems, and common law or adversarial systems. Civil law systems are derived from Roman law, where the basic source of law in the civil law system is the codes, or the body of laws, or the actual statutes, rather than a case-by-case difference in judicial systems. These inquisitorial systems are commonly used in Europe, and legislation or the passing of laws by a legislative body like a Congress or a parliament are seen as the primary source of law. Contrast that with common law or adversarial systems, and the basic source of law is judicial decisions rather than the legislature, right? Judges seek in each new case to adopt or adapt the principles worked out in previous cases to these new facts or circumstances, right? And so if you think about this, right, in America, the way gay marriage became legalized was the Supreme Court, not the legislature. The reason why abortion became legalized and then unlegalized and questionably legalized now in America is because of the Supreme Court, not because of the legislature, right? And so in English-speaking nations, they rely more on a common law or adversarial system, where the emphasis here is on the judges and the appointment of judges versus the legislature. And that's why people in America especially get so worked up about who gets appointed to the Supreme Court, and that worked up could be in a good way or a bad way. So the difference in civil versus common law is in methodological approach to the law, right? One views conflict as the best way to solve problems, right? And the other views cooperation as the best way to solve a problem. In common law, the basic argument is if two sides fight vigorously against each other, the truth is probably somewhere in the middle, but the best way to figure that out is in this adversarial fighting way. In civil law, they say, no, everyone should work together and cooperate with each other in order to find the solution to the problem. The development of judges is also different. In civil law, they're trained separately from lawyers. In common law, they're selected from accomplished and reputable attorneys, and a reliance on precedent. In civil law, only the legislature can change the law. In common law, judicial decisions can change that law. One thing to note about these two systems is that they're both considered pure systems that don't truly exist. If you were to look at law on a spectrum, there's countries that have more civil law than common law, but there's no such thing as a pure civil law system and a pure common law system. Europe is slowly moving away from civil law toward a more adversarial system. However, the pre-trial stages of the inquisitorial system are still quite cooperative. And so what that means is that the police and prosecutors will look for both inculpatory and exculpatory evidence, or evidence indicative of guilt and evidence indicative of innocence. The suspect has a fairly passive role in the investigation because the police are trying to do the heavy lifting in the investigation. This means that in an inquisitorial system, police and prosecutors should work hard to ensure that alibi claims are fully investigated, right? The defense rarely presents their own evidence in an inquisitorial system because the police and prosecutors handle most of that themselves. They want to make sure they don't accidentally convict somebody in this inquisitorial system. So let's look at a quick case study here of John Travolta. On January 16, 2012, Travolta was accused of sexually assaulting a massage therapist in Los Angeles. He allegedly grabbed the therapist's penis while the therapist was massaging Travolta, right? Travolta provided strong evidence that he was, in fact, in New York at the time of the crime. There were private jet logs, photos, receipts, all that Travolta had signed, suggesting he was actually nowhere close to L.A. The therapist initially said he got the dates confused before finally withdrawing his claim and saying, "You're right, I kind of made this whole thing up." So let's look at that in the context of these different systems. In an adversarial system, alibis are rarely presented in court. Alibis are rarely presented in court in inquisitorial systems. This is mainly because if they're supported by strong evidence, the police won't prosecute the case. And when they are presented in court, they have either very weak or no evidence to support them either way. In an adversarial system, since both sides are responsible for providing evidence, there may even be strategies to not disclose the alibi claim until trial. In adversarial systems, the defense has no obligation to share any of its evidence before trial, like the prosecution does. And we'll talk about why that matters in future lectures. So if we look at John Travolta's case, right, he claimed he was elsewhere at the time of the crime. In an inquisitorial system, the police would investigate that. The police would say, let's look at these claims, let's figure all this out. In an adversarial system, it would be up to John Travolta to do this. Or if we remember back to the case of Juan Catalan on the documentary Long Shot on Netflix, you remember that it was Juan Catalan's defense attorney that was actively fighting against the police and against the prosecutors to find evidence of the alibi claim to have Juan Catalan not formally charged. So the different systems might require different research. There's mock versus true participants. Most U.S. research uses mock participants, and research tends to differ between mock and true people, specifically mock and true law enforcement. For example, mock participants viewed relational distance as the best predictor of honesty. For example, right, if you had a stranger corroborating your claim, that would be mock participants. So that's the best predictor of an honest alibi, whereas the true police viewed the number of corroborators. It didn't matter if it was a stranger or friends. If you had 35 corroborators, that was probably the best evidence that you were in fact innocent, as opposed to having only one corroborator. So we see that this use of participants is different. Also, the type of evidence. Mock participants tended to rely on person and physical evidence somewhat equally, whereas true police tended to rely primarily on physical evidence. So the type of evidence that gets evaluated for law enforcement, real law enforcement officers, physical evidence is much more important to them. And that's also super important to know when talking to attorneys in real alibi cases. If you can find more physical evidence, that will be better. I do want to make this note on race. As editors of the text Alibis and Corroborators, Dr. Kinsley and I attempted to find someone who would write a chapter for us on race and alibi corroboration, and we couldn't do it. There is such little research on the topic that most researchers didn't feel comfortable writing even a few pages on it. And that's how we decided to talk about this chapter of differential legal context and how alibis might be viewed in these differential legal contexts. What kind of issues could that cause? What does it say about a field that's only tested these effects on white college-age participants, right? This field is so young and so new that we actually haven't had full coverage of a lot of these effects, which means these lectures even that I'm giving throughout this playlist and in this course might actually become outdated in a number of less than a decade if we start doing research on true participants instead of mock participants, if we start finding out new things based on race and alibi corroboration, if we start examining some of these effects cross-culturally and we find out they don't work, we might have to throw a lot of this out and develop even more. And that's the process of social science research. We have ideas, we use these ideas to make new ideas, but we can't be so married to these ideas and so in love with these ideas that we're too rigid to be able to change as new evidence comes forward. The best researchers are guided by the data and by the results, not by their preconceived notions and their preconceived theories about an idea. And this research is happening in the world right now in real time today. So with that being said, as always, it's a pleasure. If you guys have any questions, feel free to drop them down in the comments section below, and I will talk to you guys soon.